and also director of the Kentucky Intellectual Property Alliance, and will be hosting us today. The Kentucky Intellectual Property Alliance, or KIPA, is a program of the Kentucky Commercialization Ventures Initiative and KSTC. The mission of KIPA is to foster an effective ecosystem and marketplace to facilitate the creation, protection, and advancement of intellectual property in Kentucky by serving as a connecting organization for statewide companies, organizations, and innovators. So if you're not already a member or interested in learning more about KIPA, you can find more information along with the form to join for free on KYIPA.org. I did want to give a big thanks to all of our board of advisors that are on with us today. So they've been crucial in the formation of KIPA and then also providing guidance since then. So big thanks to them. I will get us started with just a few Zoom items. First, today's webinar is being recorded. We'll be emailing out a link for the recording to attendees and our members. Second, we do have captions available. Those can be turned on or off at the bottom of your Zoom window. We'll also have the transcript of the webinar available after we wrap up if it's needed. You can just shoot me an email if you'd like a copy of that. And then lastly, as we are hosting in the webinar format, all participants are currently muted, so you can place any questions or comments in the chat or Q&A area, or you can raise your hand if you'd like to be unmuted at the end of the webinar. And those are all just down at the bottom of your Zoom window. For any questions, we will address those at the end of the presentation. And if we don't get time to address everything, we'll connect with you afterwards. So today we are excited to welcome Ajwa Anim and Julia Saladin of HGF. Ajwa is a trademark director for HGF. She provides advice to a wide range of customers, including businesses in fashion, accessories, food, retailers, financial service providers, and a whole other wide range of companies. And then Julia is a German attorney at law at HGF who carries out German and international prosecution and litigation IP work. She advises on all aspects relating to German and international trademark, design, and competition law, from developing IP strategies to conducting trademark searches and handling different national and international trademark portfolios. So thank you to both of them for joining today, and I will hand it over to you all now.
Thank you, Caroline. I'm just going to check whether everyone can see my screen.
Yes.
Perfect. Okay, so hello everyone. As you can see from our pictures and from up on the screen, I'm Ajwa and Julia, and thank you for having us, everyone. We just wanted to say a few more lines in addition to what Caroline's already said. We're from HGF, a pan-European firm. We have 22 offices across 6 European countries, and we provide advice in relation to all aspects of intellectual property. And I'll just hand over to Julia to say a few words too.
So for me, from the HGF Munich office, and as Caroline already mentioned, I'm doing mainly trademark law, trademark prosecution litigation as regards German trademark law and EU trademark law. And today, since our focus is EU and UK trademark law, first of all, we want to give you a bit of an overview what we will talk about today. And Joa, please, the stage is yours now for giving our table of today's webinar.
Sure. So for today's webinar, I just thought we'd go over a brief overview of the structure. We're going to have a short discussion about what is IP. We're going to focus on trademarks because that's our specific area of expertise, even though we do other things, and the firm offers various IP opportunities and advice. We're going to look at the considerations to keep in mind before seeking protection, discuss the registration process itself, and other things to have in mind once you have your registration certificate. And finally, we'll wrap up by discussing the differences between the EU, UK, and US trademark systems.
And in this regard, first of all, we have to have a look at what IP rights do we have. So first, trademark law, trademark rights, which are signed to protect brands. We have copyright, which is the protection for created works like movies, photographs, databases, films. We have design rights. The design rights are rights which protect the visual appearance of a product. And in contrast to that, we have patent rights. Patent rights relate to technical inventions, for example, either for a specific machine or the procedure which is used in this machine. And last but not least, we have trade secrets, which concerns that information should be kept confidential, which you probably all know, and the conclusion of NDAs. And since our focus is trademark law today, so we will first have now a look, what is the function, the nature, and the benefits about a trademark law.
So a trademark is a badge of origin. It's used to distinguish the goods and services provided by one undertaking from those of another. And what can be a trademark? It can be a word, a logo, shape, color, sound, packaging, and a few other things. And a trademark registration gives protection in relation to the goods and services that are contained within that application or registration. What's a protection a trademark registration gives is that it provides the owner with an exclusive rights, but with limitations. So a trademark registration can be used to stop a third party using a mark that's similar or identical to the registered mark and covering similar or identical goods and services that are protected within that registration. And in certain circumstances where you're able to also show reputation in relation to your trademark, you can use the trademark registration that you have to stop third parties from using identical or similar marks, but in relation to wholly dissimilar goods and services. And I thought that it would be a good point for us to contrast registered rights with unregistered rights and how we have protection for that in the UK, in the EU, and also in Germany, as we have the benefit of Julia's expertise here. So in the UK, you can have protection for unregistered rights under the law of passing off. And it's actionable, and people do enforce their rights here. It's just, it can be quite expensive and onerous because an owner has to show that they have goodwill in a sign and show that there has been a misrepresentation by a third party of another sign that causes confusion in the mind of a consumer in relation when they comprehend that latter sign, and that misrepresentation has caused or is likely to cause damage to the goodwill of the original owner. And I think there are other types of unfair competition in the US, but also I thought it would be good for us to look at what goes on in the EU and Germany. So over to you, Julia.
So in the EU, as you may have heard from the conditions for passing off in the UK with the EU, I think it gets even more difficult because in the EU, we do not have like a supranational system for unregistered rights in the EU. So it depends all if each EU member state recognize such unregistered rights. And for example, in Germany, we have for unregistered rights recognition for so-called company names. Company names is a name how you designate your company, and if this company name is used in a course of trade in Germany, then you have a protection as a company name right. And this company name right as an unregistered right can be used as the basis for an opposition against the German trademark application, but as well second, and this is the interesting thing, to be the basis against for an opposition against a EU application. So in this regard, bear in mind, unregistered rights exist in Europe as well, but you need to check in each jurisdiction of the EU member states if they recognize such rights or not. We will go now to the benefits where Adjoa will tell you as well what's the difference between unregistered right and a registered right, and which sometimes have benefits to have as well a trademark which as a registered right.
So with trademark registrations, usually we recommend that you carry out some pre-registration checks. And these checks are important because they help identify any identical or similar earlier rights that may pose an obstacle to your use of and registration of your proposed mark, even before the registration process begins. And even if any issues haven't been highlighted then, securing an early registration before launch itself exposes potential conflicts that you need to be aware of or are helpful to be aware of before launch. And although having a registration does not prove to be like an exclusive absolute right, it is a good indicator that there is a low risk of IP-related litigation in relation to your brand. And finally, once the registration process is complete, like any other registered IP right, this trademark gives the owner an asset that adds value and credibility to the business. You know, it's an attractive prospect, especially when you're selling the undertaking or seeking investment or collateral. So I hear you say, right, you've convinced me, I want to register my trademark. What do I need to do? What are the steps I need to consider before I go forward with my application?
So the first question, which you obviously have to be considered, what is the proposed mark? So what sign are you using for selling your product? Is it like a name or is it a logo? If it's a logo you put on the product, do you have the copyright for that logo? Because if you don't have, then your trademark could be objected on the basis that you don't have the copyright for the logo used. The other point, what Adjoa already mentioned before, is like for what goods and services do you want protection as a trademark? In this regard, one thing is to consider what are your current goods and services you want to offer under the trademark, but also do you have any expansion of your business activity in the next 3 years? For example, if you're doing now just downloadable or recorded software, but you want to go in the next 3 years, it's really likely that you want to provide software as a service. Then this should be also be bear in mind when filing now a trademark application, because once a trademark has been filed, afterwards you cannot amend the list of goods and services which are covered by the trademark application. As such, you would have to need to file a further application, and this would mean even more costs again. So rather think now, what is your business activity at the moment, as well as in the next years. The next question would be, where is your business activity, like in a territorial way? Are you only offering your goods and services, for example, in the US, or are you already on the EU market or the UK market? For a trademark protection, in our opinion, normally first, or the core area would be that you receive a trademark protection in the country where your business is really active. And what Adjoa already mentioned before, the next question is the mark free to use? In this regard, like clearance searches are recommended if there are any prior identical or similar trademarks covering identical or similar goods and services. Because the worst thing what could happen is that you start with your business, you put up some reputation for your goods and services, and after 3 years, a competitor or an other third party come and say, look, we have this prior trademark, you have to change your name. And this is something which should be avoided for your business, as well as for avoiding any damages claim and the like, which could be asserted if a third party invokes prior trademark rights. Other consideration in this regard for making a trademark search is, when is the launch date? Of course, what is the budget? And with having all answered these questions of what is the mark, what is goods and services, in which territory you're active, we are coming now more to like a formal part of our webinar today is, how is the registration process? So normally in the UK and EA, you submit an application with the respective trademark offices, where where you indicate the name of the mark or the logo, the goods and services. You submit the application to their respective trademark offices, and then it will be examined by the trademark examiner, where there are 2 points where they examine the application. It is first, if the goods and services you have indicated in the trademark application are sufficiently clear, because normally, or not normally, in the EU and in the EU, the trademark offices, they accept broader terms in contrast to the USPTO, where it has to be really specific as regards the commercial use of the term. So in our jurisdiction, we are a bit more flexible, I would say. The second point, which will be examined by the trademark examiner, is the trademark sufficiently distinctive in order to be registered as a trademark? As well, here there are differences from the last years. We experienced that sometimes the USPTO grants more trademarks as the KYIPA or the AUIPO, the European Trademark Offices, because the European Trademark Offices sometimes say, oh, this is pretty clear, even if it's not an English grammatically correct word, but the consumer will understand what it means, and that's as such will not have a sufficiently distinctive character. So these are the two objections, which could be like the goods and services are not clear, or the mark is not sufficiently distinctive, where you would maybe get an objection by the office. If the objection is overcome, then you come to the next stage, which will be that the trademark will be published for opposition purposes. In the EU, the opposition period is 3 months, while in the UK, we have a 2-month opposition period, but it can be extended by one further month in the UK. And after everything is done, no opposition has been filed by a third party. We are coming now to the final stage, which will be that the trademark will get into the registration process, and you will receive a lovely trademark certificate. Actually, it's not that fancy, because you will not receive a hard copy like you will receive in the US. You will have just an electronic file, but then you have the certificate as at your hand, showing that you're the owner of this respective trademark. Now we have a bit of, the registration process, but in this regard, Ajoa will now mention some specific additional points to that. And Ajoa, the stage is yours now.
Sure. So, we're aware that you can register rights all over the world in various countries, including the US, the UK, the EU, Germany. But also, one of the ways we can do this, instead of just filing directly at these national registries or EU or the EU registry, is to use the international registration system. Some of you may already be aware of it, but for those who aren't, the international registration system is the bundle of rights managed by an international protocol that allows for a centralized management of trademarks in over 80% of the countries worldwide. It's managed by the World Intellectual Property Office in Geneva, and it allows you to seek protection in many countries by basing an international registration application on a home application or registration. So for this presentation, let's say that we're basing it on a US application or registration. So once you have that base application or registration, you can then file an international registration application, then select the countries in which you wish to seek protection, so long as each of them are members of the international protocol. And the EU, even though it's a supranational organization, is also a member of that protocol, so you can select that as a territory to protect. And one advantage of this is it's usually cheaper to do this than filing directly through national registries. As much as we'd like to get work from you in relation to UK applications and German or EU applications, the international registration does have its advantage, because it means that you're centralizing everything. However, if there are issues with a designation, which is what we call the various rights that you've selected in these territories, then if, for example, there's a problem in the UK or Germany, then you'd instruct us to deal with it, because you need to instruct a local associate to deal with any issues that's come up. So that's one of the pluses, having that centralized kind of bundle of rights to manage. One of the minuses is that for the first 5 years of the international registration's life, it's tied to that base US rights. So if for any reason something happened to the US rights, it was refused, it was opposed, it was cancelled, then the whole international registration bundle would collapse. However, there is always something that can be done to rescue that bundle, because you can convert those rights, those various designations, into national rights. So at least you're not losing that earlier filing date that you filed the application in, which is really helpful. So that's the international registration system, which again, we're still able to assist with if there are any issues along the way for those relevant European designations. Another sore topic, or no, the only sore topic, I should say, is Brexit. We're still reeling from the divorce, but you know, these things happen in life. So in relation to the international registration system, there are some designations that had protection in the EU as a whole, and that was before the UK left the EU. However, since Brexit, these EU rights, which are protected under an international registration, have been hived off into EU rights and comparable UK rights. And some of these UK designations that have been hived off still have the addresses of the original firms that file these applications. So if we're talking of a US, it will be a US address for service. Now, the recommendation is that you have a UK address for service instead of a foreign address for service, because the UK registry has changed the way it notifies owners of certain actions in relation to their UK designations. So when a UK designation is cancelled or rectified, the UK registry will only notify the holder or the foreign representative by post and give them 1 month to file a UK address for service and confirm an intention to defend. But things run a lot smoother if you already have a UK address for service, a UK representative. So the recommendation is that you update your records and make sure that for any rights in the UK, you make sure you have a UK representative. And also, notwithstanding the international registrations that had protection in the EU, all EU rights were also hived off to EU rights and UK comparable rights. So there's also a law that will require that from the 1st of January 2024, all UK rights that were hived off from the original EU registrations or pending EU applications that were re-registered will have to have a UK representative. So that's kind of getting our house in order ahead of the 1st January deadline. So that's just something to bear in mind if you have any international registration rights that have protection in the UK already. And one final point I wanted to mention in relation to the registration process was the priority system. And that's basically a 6-month buffer that allows you to kind of stagger applications. So there's a convention that allows you 6 months after the filing of a first application anywhere in the world to then file subsequent applications within the 6 months and backdate your rights to the date of the first filing. So for example, if we filed an application, a trademark application in the US today, 20th September, and it was the first filing of the mark, we'd have until the 28th of March to file subsequent applications in the UK, in the EU, and anywhere else that is part of this convention, but also claim priority back to the 28th September US filing date. And that's helpful to some businesses, you know, for example, if they want to launch but see how a brand goes. So maybe they launch in the US and then they wait about 3 months to see whether it's successful outside of the US, then they can file subsequent applications. And also it happens when there are budgetary restrictions, so that you kind of stagger them and see and spread the cost of the filing program as well. So that's really helpful. And so now you have your registered trademark, you kind of go, what do I do with it?
Amazing, great, this trademark. I'm the owner of this trademark. What do I do? So first of all, what you have to bear in mind is that you have to renew your trademark every 10 years, but you can renew it indefinitely. So there is, in contrast to patent law, no no time limit as long as you pay the renewal fees. The other decisive point in this regard to mention is the use of the trademark. And then in this regard, it is like bear in mind, use it or lose it. But there is a so-called 5-year grace period of non-use from the date of the registration on the mark. And within this 5-year time period, you don't have to use your trademark in order to invoke trademark rights against a third party or to file an opposition. But this grace period of non-use is some kind of, tricky, because after this 5 years, you really have to use your trademark for invoking rights against third parties. Otherwise, after this 5 years, a third party could already file 1 day after this 5-year period ended a revocation action based on non-use against your trademark. And then in this case, you have to provide proofs of a right preserving use of your trademark exactly in that grace period of non-use, where you thought, oh, I don't have to use the trademark now, I can wait. But this is a bit tricky, because then in this case you really have to show even in that time the right preserving use. So as regards the right preserving use, it is always helpful to keep advertising material, invoices, and other documents like photos of the products in a folder, so that in case a third party files any action against your trademark, that you are prepared already. Another point is of when you have the registered trademark, of course, you have the benefit of enforce it against third parties, which are younger than your own trademark application. For doing so, of course, you need to be aware which are the trademarks filed after your own trademark. And the KYIPA, they provide notifications about EU trademark applications, but the KYIPA does not provide notices as regards like a trademark application in EU member states. As such, it's always good to set up a watching monitoring service in place, so you could see what other, maybe as well competitors, what trademarks they are filing, and then to be as well aware of the opposition period when you have to file, or until which time you can file a opposition period against the opposition against this trademark. In this regard, if you have noticed the opposition period, or the opposition period has passed, there's always the possibility to file as well a cancellation action. But this cancellation, the costs are a bit higher, and as such, it's always good to start with the opposition, and then maybe many cases could be also settled, because some trademark owners, if they are probably weren't aware that there are any prior trademark. So setting up a watch service is good. Sometimes if you have products which are highly to be counterfeited products, like the fashion industry or jewelry, then it's also possible to set up customs applications for action. In this regard, I experienced or already heard from UK colleagues that the German customs are supposed to be very good in the Munich airport. So this is a thing to consider after having a registered trademark, which is subject to counterfeit products. And as well, another thing, if you're not using your trademark, but maybe a distributor is losing your trademark, it's about licensing or assigning rights. So there you have several things to think about when you have a registered trademark. And as the last point, we want to highlight now some differences between EU, UK, and US trademark law points.
Yes, so we thought we've spoken for about half an hour. What can you distill the presentation into? What are the points that we'd like you to kind of take home? And then we thought, what better than a table or two? So we thought we'd look at the UK, EU, and USA jurisdictions, and kind of point out some of the differences or unique points that are relevant to each one. So in the US, there are various filing bases. You know, for example, you have an intent to use a trademark or basing your application on actual use, whereas in the EU and the UK, that doesn't exist. You just file the application. So sometimes we send instructions and we get questions back and we just have to think about these things, whereas with us, we just get instructions from you and we file the application. And as Yulia mentioned already, in the EU and the UK, there are broader terms that are acceptable. In the US, I think it's the everyday commercial meaning. I think that's the term that's used in examination reports. So we have to be a bit more specific when we're dealing with US lists of goods and services. And in relation to declarations of intent to use, in the EU, you don't have to declare that you intend to use a trademark when you're filing an application. However, if you file an application with no intent to use it, and for example, what some of us call defensive applications, these eventual registrations can be cancelled on the basis of bad faith because you're trying to stop other people from obtaining those rights. In the UK, you do tick a box on the application to confirm that you have a declaration of intent to use, but you can also apply to cancel registrations on the basis of bad faith. In the US, as you all know, declarations of intent to use are applicable and can be part of the filing basis, you know, if you haven't used the mark already in the US. And with the advertisement period in the EU, no ifs or buts, it's 3 months. In the UK, as Yulia mentioned before, it's 2 months. And then if you have an interest in possibly opposing an application, then you can apply to extend it to 3 months. But once it's extended, only the party that has extended it has a right to, or an option to file an opposition within that 3-month period. So if you don't apply for an extension at the end of the 2-month period, then you've kind of lost your chance to object to that until it goes to registration, and then you can think about applying to cancel the resulting registration. And again, in the US, it's 1 month, but it can be extended up to 3 months. And in relation to evidence of use before registration, in the EU and in the UK, it's not applicable. Whereas in the US, if an application is filed on an intent to use basis, after it's past the advertisement stage, before it's formally accepted for registration, we'd have to submit evidence of use and a declaration. So that's not something that we have to consider in the EU and the UK. And as we discussed previously, you can rely on unregistered rights in each of these jurisdictions. However, you can only, in relation to the EU, you can only rely on the unregistered rights within each member state. So you can select a member state or a number of member states upon which the unregistered rights you have in those particular member states to object to an EU trademark application or registration. And oh, excuse me, I got too excited there. And in relation to post-registration declarations of use, in the EU and the UK, it's not applicable, whereas in the US, it is, and we have to submit these every few years. So that's something to keep in mind as well. And it's the same in relation to the declaration of incontestability. I know it's not a definite in the US, but it's an option, whereas in the EU and the UK, it's not applicable at all. And that actually brings us to the end of our presentation, but we'll open the field to questions now. And if there are any later questions, please feel free to connect with us on LinkedIn. I think we've got, at the end of these slides, we've got our LinkedIn contacts. So if you want to connect with us for those, please feel free to do so. But I'll pass back to Caroline so that we can deal with any questions that come in. And I'll stop sharing.
Thank you all so much. Great, a lot of great points in there. Let me see. Yeah, so if anyone has any questions, again, you can put those in the Q&A or the chat area. I'm not seeing any right now, but while we give everyone a few minutes to think on that, I will add for those in Kentucky, if you're not already familiar, Kentucky does have the STEP grant program. And as part of that, if you are doing export internationally from the US, you can actually get some of your international trademark application fees reimbursed. And I will put a link to their website in the chat. That's always a good resource if you're looking to do international business. Oh, and Mary is on and actually just put more info in there. So everyone can see that there as far as what's applicable through that program. So it's really great for those looking into doing exporting to the UK and EU if you're on and interested in more of that. Okay.
So either we were really, really interesting and clear, or we were really boring.
I personally thought there were a lot of really great points. So, and I liked the closing with the tables. Always appreciate a table.
Yeah.
And I think it was good too, just because for those that are on, they are, you know, if they're familiar with the trademark system, we're going to be more familiar with the US one. So it's good to see that comparison. Okay. Any last questions? Okay, well, we can stick around for a few more minutes. And if you all have any questions, again, you can also email me. Oh, okay. So Paul did say clear and
Got it,
excellent, no
Paul.
questions needed. So, so again, thank you all for the presentation. We definitely appreciate your time. And thanks again to everyone for joining. Hope you enjoy the rest of your week and the weekend. Hopefully this weather clears up. So thanks everybody.
Thank you so much.
Thank
Bye.
you.